All right, so my topic today, this is directed to individuals, and it's more of a plea than a rant. Please stop treating your employment contracts as a formality. And Rob, if you could put up that graphic we talked about. So we are all used to seeing something like this online. You want to read an article, see a video, and this comes up, and this is what stands in between you and reading or seeing whatever it is you want to see. So what do we all do when we see this type of thing? We click I agree without reading it. Or if it's one of those that makes you scroll down, we scroll through it and then click on I agree without even reading it, which is, I mean, some other lawyers may disagree. That's the reality of what we do. The problem is that's what most people are effectively doing with their employment contracts. They're being handed a piece of paper or probably several pieces of paper, and they're just signing it without even reading it. And unlike those online things where maybe you're trying to, get through that web page on one simple trick to lose belly fat or whatever it is that you're going to, this is your livelihood. This is your job. This is your career. This is an employment contract which will fundamentally establish or remove your rights as an employee. It's critical, and it actually shocks us, within Rudner Law, how often people sign off on these contracts without even taking the time to review them, let alone have them reviewed by an employment lawyer. And this is true for everyone. I mean, we have seen senior executives, HR professionals, lawyers, all of whom have signed off on contracts that dramatically impacted their rights without even giving it a second thought. And the argument I often get is, well, I saw it, but I didn't bother going to see a lawyer because I assumed the company knew what it was doing. And what I always say is, yeah, they did. And what they were doing was protecting their interests. There is very rarely a contract, an employment contract, that is designed to protect the employee's interests. If you're being asked to sign a contract, it's generally for the benefit of the company. I'll give you a couple of quick examples of what we typically see. Biggest one is termination clauses. People sign away their common law rights to severance in these contracts. So imagine that you're employed for 8, 10, 15 years, and now there's going to be a downsizing and you get a severance package and you get 8 weeks. And we've had people sitting in this boardroom and they start off by being convinced that it's a mistake. The company must have screwed up. I've been there for 15 years. They owed me far more than 8 weeks. And we have to explain to them that no, when you started way back when, you signed a contract that limited your entitlement to the employment standards minimum. So 8 weeks or whatever the case may be is all that you're entitled to. And then to add insult to injury, we often see the same person who they just got their 8 weeks of termination pay, but they also agreed to a non-compete clause for 2 years. So they're now being told they're going to get 8 weeks of pay, but they can't basically work in their industry for 2 years. And yes, I'm sure some of you are thinking that's probably not enforceable. It's very possible you can challenge that non-compete, but it's going to cost you a whole lot of time and a whole lot of money to do so. Whereas if you'd read it at the beginning, you may well have been able to take it out and not have to go through that fight. Or we've also seen people who have been signed off on clauses that say you can be relocated to any of our locations. So they just got notice that effective 2 months from now, they're being transferred, in one case, from Toronto to New Brunswick, and another case from New Brunswick to Vancouver. And they don't even have the right to compensation for their moving costs because the contract was very clear that they're on the hook for that. These are the types of things that we see far too often. And I hate to say this, but at the hiring stage, although everyone's excited about the new job, it's not the time for trust. It's also amazing to me how often I hear stories about how someone was promised something and they're told by the hiring manager that, well, I can't put this in writing, but I know we're starting you at a low salary. 6 months from now, we're going to review your salary. Or don't worry, I know that our policy says that nobody can work from home, but you can work from home 2 or 3 days a week. That's not a problem. Or I know that you're leaving your current job and giving up a big bonus. We're going to give you a bonus to make up for that. If it's not in writing, it's not in your contract, you have no right to it. So please don't trust the company in that regard. Employers are getting far more aggressive with contracts. And if you get the job, don't, even though you're excited about getting the job, don't just sign off because you're probably signing away significant rights if you do. And one objection I often get is, well, who cares? I know the company's not going to negotiate with me. So what's the point? I can tell you quite honestly that we've helped a lot of people to renegotiate that initial offer. And a lot of times companies will just give it a shot. They will try to impose a very oppressive contract, knowing that if the person comes back, they'll negotiate. So in many cases, things are negotiable. If it's not, at least you're going to go in with your eyes open, knowing what you're giving up, and then you can make your decision. So I know it sounds self-serving. You need to go see an employment lawyer before you sign your contract, not your cousin who practices tax law or your neighbor who does real estate law, someone who specializes in employment law. And quick message to employers on a similar subject: if you're going to go through the process of putting contracts in place, make sure they're enforceable. Because the other thing that surprises us here at Rudner Law is how often people have contracts that, if challenged, would never hold up in court, either because they're badly worded, maybe they were downloaded offline, maybe they're taken from someone's previous job, or they're badly implemented. And I could go on for an hour about that, but the worst example and the most common thing is this. You hire someone, they show up for their first day of work, you hand them their contract and ask them to sign it. At that point, it's too late. They already had a verbal agreement, and that's why they're there that day, because you hired them and they accepted it. That's a verbal contract. You can't just replace it with a written contract unless you give them something new. So have them sign the contract before they have been hired. Otherwise, that contract that you have, probably not worth the paper it's printed on. So that's my 2 cents worth for today, and you got it here for free.